so I'm going to be talking about adoption, another way that you can create a family. And so the one thing to remember about adoption in Virginia is it's a creature of the code. It is, you have to follow the code to the T, otherwise you're going to have problems with your adoption. So the first thing becomes, who can adopt? And so in Virginia, you can adopt as a single unmarried individual or a married couple. We don't allow for second parent adoptions in the sense of two unmarried individuals adopting a child together. And if you are married, your spouse, your partner needs to be joining you on that petition, because you can't be married and adopting alone. You know, your partner's got to be on board with bringing a baby into the house. There is always, in the legal world, and Lindsay knows this, there's a general rule and then there's an exception to the general rule. So you are allowed, if you were previously married and now you are separated or divorced actually, you are allowed as long as you are standing as a parent to that child during your marriage. So if it's later down after your divorce, you want to adopt your former stepchild and make them your child by adoption, you can do that. So I'm going to talk about 4 adoptions. The first one I'm going to talk about is parental placement. And so that is when you have the relationship, the connection between the birth parents and then the adoptive parents. And so a lot of times that can happen through mutual friends, church groups. There are even websites where couples will go and they will, put pictures of themselves, explain their family background, what type of family and how they want to raise their child. And then you have your birth parent selecting who the adoptive parents are going to be. It's going to be very important in that process that you have legal counsel from the beginning for both. You cannot be represented by the same, very similar to what Lindsay said when you're talking about gestational carriers and the contracts. Your birth parents need one attorney, and then your adoptive parents need another attorney. Because the adoptive parents, your attorney is going to be making sure you have the proper documents in place when that baby is born, so that you can take that baby home from the hospital, and that you have the medical authorizations and the power of attorneys, because you're not technically going to have any form of custody yet. So what happens is once that baby is born, we will then go to the Juvenile Domestic Relations Court, and we will have a hearing, and those get precedent on the docket. So that generally is happening within 10 to 14 days after birth. And at that hearing, your birth mother is going to consent to the adoption. She's going to sign the consent, and you're going to get legal custody. If birth father is involved, he can consent ahead of time. He can come to court and consent. If he's not involved and she doesn't know who he is, or you do the putative father registry search. The one thing that is scary with the birth placement adoption is you're going to have birth mom. She's going to come to court and she's going to sign the consent. She has 7 days where she can revoke her consent. So you're going to want to lock yourself somewhere, drive to another state and lock yourself and throw your phone in a lake. But you can't do that during those 7 days because she can change her mind. There is an opportunity for that to be waived if the child is over 10 days old and she has her own independent counsel. They've advised her that you can waive this revocation period. So then after that process happens, once you get the legal custody, then we're going to go to circuit court. So this is a 2-court process. So we're going to go upstairs to circuit court, and then we'll file the petition for adoption. The court's going to enter an interlocutory order that's going to give you custody of the child it's a temporary order, so to speak, for 6 months. It's going to allow for your post-placement visits to happen to make sure everything is okay. Your agency that you're working with, they're going to do 3 post-placement visits specifically placed out. And once you've hit that point where you've had the child for six months, then you're going to be able to finalize the adoption. So the scary thing, just one of the cons of parental placement and working with families that I've worked with in the past is the birth parents can change their mind. And I've had that unfortunately happen to a same-sex couple that I was working with, where the birth parents, they yo-yoed them the whole time. And in the end they said, we're going to find another baby, because your home study that you get is good for 1 year. So it's a situation of emotionally we can't ride this roller coaster with them anymore, so we're going to find another baby and another family that works for us. The next adoption I'm going to talk about is an agency adoption. So like when you're working with Adoptions from the Heart, with Nicole, who couldn't be here for us today, that is where the agency has not only the child, but also the adoptive parents. So you've already gone through the home study with this agency, and what they have done is they've already been working with the birth mother, giving her birth mother her counseling so that she's aware of her options, and Generally, it's before the baby comes, because then they're very quick, they're at the hospital, they're getting the entrustment agreement signed by birth mother. And that is the agreement where mom is giving custody to the agency. Again, there's a window for that revocation. But the nice thing about the agency adoption is once that child is placed with the adoptive parents, that period is passed. So you don't have to worry about those 7 days where you're going to be nervous that birth mom's going to change her mind, because the agency is not going to give you a baby with that possibility there. And so what's going to happen is once that child is placed with you, that's when you should start seeking your legal counsel. Because then you're going to have a 6-month window again where you're going to care for the child. You're going to have legal custody of the child through the agency because they've placed the child with you. And then they're going to do 3 post-placement visits to make sure everything is okay. At that point, we're going right to circuit court this time. So we're filing our petition for adoption in circuit court. And once you hit the 6-month mark, and then what we have is the court doesn't have to enter an interlocutory order anymore because you've already had the child for 6 months. But what the court does is they enter an order of reference. And that's going to direct your agency, Adoptions from the Heart, to do their report, consenting to the adoption. And once that report comes back, we file the final adoption. I do a lot of agency adoptions. We do not go to court for them. You do not have to, because when you're working, you have your legal counsel and you have your adoption agency, so everything's running smooth. With the adoption at the same time, we handle name change. So, the baby might be born with one name on the birth certificate, and then we can change the name, and we also get the new birth certificate administered. That gets mailed directly to you. So the next one I'm going to talk about is just foster care placement adoption, which is another option. Generally, that takes place later because the goal of foster care, and correct me if I'm wrong, but the goal of foster care as the Department of Social Services is reunification. That's the goal, to reunify, I'll say birth because we're talking about adoption, but birth parents with their child. And so what happens in foster care is a child's taken from their parents due to abuse or neglect. And there's a guardian ad litem there is involved, there's CASA, the social services, and what they're going to do is they're going to give the birth parents a foster care plan. And it's going to detail what it is that they need to work on or they need to improve in order to have custody of their children back. So this isn't your most, if you're looking to secure a child with adoption, birth, this is not your first one to go to, because really you have to remember the goal of foster care is to return that child to their parents. So you'll have to wait until those birth parents, their parental rights are terminated. And that can be initiated by the Department of Social Services, the GAL for the children, the foster care parents if they're ready to move forward with the adoption. But that's going to happen generally after that child's been in foster care 6 to 12 months, and then you're waiting for that child to have been placed with you for 18 months before you go through the court process. And this will be a 2-court process again, because you're going to have to get the parental rights terminated down the juvenile court. That's where you would do it. And then we would do the adoption in circuit court. Once you get to that point, it's very similar to the agency adoption. It is a quick process. The only thing, and I have a friend whose sister is fostering 3, and it's been a 2-year ordeal at this point. And because mom kept appealing, and she had 3 separate children from 3 separate fathers, so every one she lost, she appealed. So she started in the juvenile court, and then she's appealing to the circuit court. So it can be a long waiting game, and you never know. Those biological parents could correct their path, comply with the foster care plan, and then it's a situation where that child who has been in your home is now going back to their mother and father. The last one I want to talk about is step-parent adoption. So in that situation, what you have is the custodial spouse and your new spouse. You have to be on the petition together. Remember, you cannot, if you're married and you're adopting, your spouse needs to be on that petition with you. It's very uncomplicated if it's a situation where let's say, biological father consents to the adoption, or if he's deceased. It's a very straightforward process. The benefit of this one is there's no home study required. So you don't have to work with any agency for a home study. There's no post-placement visits, and it's a very direct result in an uncontested one. Now, let's say a situation where mother and her new partner want to adopt mother's child. The biological father, he could object to this, and that's going to require a court hearing. That's where the court's going to determine whether he's holding his consent contrary to the best interest of the child. They're going to look at what type of relationship he's had with this child over if he's coming out 12 years later, oh, I'm objecting to this. Well, really, why are you objecting? You haven't been around. And this is all done in circuit court directly. So then it becomes, how does this relate to the LGBTQ community? So what I've done is I've done a lot of step-parent adoptions for same-sex couples. And one thing to remember is it's just called step-parent adoption because that's under the code. Nothing in this petition or order says you're a step-parent. You are a full parent. We just don't have what we call second-parent adoption here in Virginia. So one of the things that Lindsay had mentioned was, the birth certificate. There was a Supreme Court case, Harvin v. Smith in 2017, where Arkansas Supreme Court said, no, we're not putting the gestational mother, we're not putting her wife on the birth certificate. It went all the way to the U.S. Supreme Court, and they said you can't do that. Both moms are on the birth certificate. So now, obviously, when we go and we have our babies, there's not going to be issue with one person being denied on the birth certificate. However, the birth certificate is not where you put your weight. That is a document that, yeah, it's nice and it's a vital statistic and you need it later on in life when you need to do things, but it is always rebuttable. And I give the example of, let's say, an opposite-sex couple. Wife is married. 9 months ago, she stepped out on her husband. So she doesn't really know who the father of her child is, but she births the child while she's married to her husband. He presumes he's the father. His name goes on the birth certificate. 10 years later, they're in a fight, and she says, I cheated on you 10 years and 9 months ago, and this kid might not be yours. Well, he can get a paternity test, he can go down and file for determination of parentage, and then he can find out that he is actually not his child's biological father. That birth certificate is nothing. Now, at this point, he has stood in the position of a parent, but he's a third party, because now this biological father can come in because he has biological rights to this child. So the birth certificate is an issue. And the other thing that Lindsay had mentioned, whenever we have changes to the code, they happen July 1. So right now, the code reads, the husband of a gestational mother who conceives through assisted conception is presumed to be the child's father. And the code even says that it has to be a medical instrument, I think yes. And so, believe it or not, there is case law where turkey basters have been involved. And so it's a situation where, you can go with New Hope, with Dr. Robin, and you're definitely in a medical facility, you're definitely using medical instruments. But if it's a situation where you and your spouse decided, in a lesbian relationship, you decided to try this at home, and you got lucky, you want to go out and get a lottery ticket afterwards, but you did this at home, you conceived, later down, if something breaks or deteriorates in this marriage, and things end badly, you're the gestational, the biological parent there is 9 times out of 10 going to be arguing, oh, this wasn't a medical instrument, we did it at home with the turkey baster from the drawer, it doesn't fall under the code, she's not a parent, she's not. So in a situation like that, if that applies to you, you should definitely look at the step-parent adoption to ensure your parental rights. If you decided to have children before marriage together, and I've had a couple that did that, before marriage, same-sex marriage was legal, they already knew they wanted to be together, they were committed, and they went through a crowd bank, they went through an organization, and they had children together. But the thing is, these are children before the marriage, so they're not of the marriage, and you need to make sure you're adopting. The non-biological mother in that situation needs to make sure that she's adopting, and we would do it as a step-parent adoption. Just to give some example, there was a case from the Virginia Circuit Court in Fairfax, February 2018, Apple versus Celia. And the issue in that case was whether these children were of the marriage. Now, it relates to the divorce, because if you have children of the marriage, it changes your timeline for divorce if you have an agreement from 6 months to 12 months. And what happened in this case was the court said, right now the way the code is written about husband and wife and the husband of a gestational mother being presumed to be the parent, it discriminates. And this is going to change in July 1, but this case is from February last year, and they said it discriminates, it's exclusive, it needs to be inclusive. So therefore, the mother is these are children of the marriage. Now, this case speaks nothing about any custody battle, so I presume they probably had a separation agreement in place to address that. And then, a week after that case in February of 2018, there's another case from the Court of Appeals, Hawkins v. Greece. And what happened there was it was an unmarried lesbian couple together for 10 years, and they had children together, but they never got married, they never did a civil union. And the relationship ended and things ended badly. So then you had the non-biological parent trying to assert herself as a parent. And what the Court of Appeals said that the court held that disputes concerning the relationship is you're either a parent through biological procreation or legal adoption. And so this court said you were never married and you could never adopt the child, so technically you're not a parent, you're a third party. In a situation like this, with this couple, you know, the non-biological, she cannot adopt because they're not married. But if marriage is not what you want, but you and your partner want to raise children together, then what you need to do, and as Lindsay said, is you come in and we do a custody agreement. And we put that, and that gets filed down in the juvenile court. You don't need a court date, you don't need to appear because it's going to be by consent. But that way, if something breaks down in the relationship later on, you're not starting off as a third party. Because a third party, you have to fight over the parental presumption for the biological mother here, which becomes very hard in a situation. So this would be a custody agreement that says joint legal and shared physical custody, and it puts you on the even playing field so that if something were to happen and you had to litigate that issue, you're a parent in that sense. And so again, if you had children before you were married, you should consider doing the adoption. If and you know, I've looked into it, you know, the National Center for Lesbian Rights still recommends doing an adoption just to make sure everything is fully protected. Like Lindsay said, court orders are giving full faith and credit. So you could move to another state that's really, and they, you know, they're not haven't caught up to anything yet or on the books, and you're going to be okay because you have an order. I'm due in November, and my wife and I, we're going to do the adoption. Just it's not going to require any court appearance from us. It's going to be just paperwork, but we're doing it just to make sure if anything ever happened that she would be fully protected as our child's parent.